They'll tell jury to disregard, but there's a decision that the court has to make to say, you know what, this jury is disqualified. We're going to have to get a new jury and come back at a later date. So that's how serious it is.
So a jury might be more likely to find fault against a defendant, the courts have ruled, if they have insurance.
Absolutely. Well, they know it's prejudicial, right? They just maybe, gosh, it's not this person it's the insurance company's going to pay it. Let's give a bigger verdict. Let's give a bigger result. So they have decided absolutely you cannot disclose the existence of insurance.
What about sympathy? Is that another factor too, that a juror might be like, oh, I'm more sympathetic because they have insurance?
Indeed it is. So, right. So it's just one of the things they kind of analyze. They just think that it may tip the scale. It may take, away from the facts of the case. It may influence a jury to say, well, this person's nice or this person's not as nice. And oh, by the way, they're not paying the bill anyway. So, let's kind of do what we're going to do. So that's one thing. Out of bounds, can't say it, no how, no way.
Wow. Yeah. And Matt, if it was to come out, like if you accidentally said it, possibly mistrial right off the bat. Oh,
yeah, usually. I can promise you that the insurance, if I said it, the insurance defendant, the insurance company client, they'd want a new jury. They'd say the judge would say, well, I'll instruct the jury to disregard, but I promise you the other side would say, Judge, too prejudicial, we need a new jury in here. We call it a mistrial.
Gotcha.
Come back for a later day.
What about, is it, and it's kind of, you see the question down the bottom of the screen, would it be an effect to the jury if they think that y'all have the same insurance? Like, oh man, they're in it together. Well, it's a double whammy.
Exactly.
Going on here.
That's a whole nother thing to consider, because you may say, gosh, we have the same insurance company, and if I give her a big award and my insurance company has to pay, what if my rates go up? What if I'm getting a new bill? So that's part of it too. And another thing, Kenny, on that list we haven't touched upon is settlement offers. Now, I'm not, the first rule sometimes I'm not overly, I have issues with, but the second rule about you cannot mention settlement offers, I completely agree. That makes sense to me. Because here's the rule. Number one, you want to encourage settlement, right? And two, there would not be settlements if the defendants knew whenever we made an offer, the plaintiffs would stand up and say, gosh, jury, gosh, judge, they're at fault because they've offered me $10,000. And if they offer me that kind of money, they're at fault. So settlements would cease in civil cases. And as you know, right or wrong, Kenny, it must be probably 97% of cases filed get resolved by settlement.
Right.
So settlement is a big deal in litigation. So
as we're talking it out, it makes sense.
That makes sense.
It does. Yeah. But at the same time, it just seems so counterintuitive of all the things that are going to be brought up during a case and a trial, and that you don't mention. And by the way, they have insurance.
And here's another little thing I'd like to throw in there too, if we have a little time, and that is what's called subsequent remedial measures. Also can't be.
I know.
I
don't think we have a graphic for that.
I know you don't. I threw it at you.
Yeah, you did.
Subsequent remedial measures. So if, for example, you have a slip and fall case and there was a problem with the staircase, they want to encourage people to fix problems. All right. And what they don't want is, gosh, if I fix this problem, the plaintiff or the plaintiff's lawyer is going to say, I told you there was a problem. They went out and fixed it the next day. So the courts also say we want to encourage people to fix things, and as a result, we're going to let them do this without being penalized, and we're going to keep that information away from the jury because we feel they would, unfairly infer that there was an issue, or they think it would be prejudicial. So they want to, just like they want to encourage settlements, they also want to encourage people to fix known problems.
Well, that makes sense.
And that does make sense.
Okay. So all of these things have been worked out for us. All right, now let's get into, we got a great email question to go with tonight's show of what your attorney can't say in court. This comes in from Joseph, and Matthew, he writes you, I was in a wreck a few weeks ago, and I feel like the insurance company is giving me the runaround. I don't think they're offering me enough money on my accidents. What are my options? Joseph, I think you're probably identifying with a lot of people out there right now.
Yeah, Joseph, I truly am sorry. And yes, you are in the claims process. And I have to tell you, it is an adversarial process. And what that means is the goal of the insurance company that you are dealing with to resolve your claim as cheaply as possible. It is not their goal to be fair. It is not their goal to be reasonable. It is not their goal to make you in any way happy. It is their job to close your file as cheaply as they can. And like everything else, listen, The truth of it is, over my long career, some would say, long way to go, many moons. There are some great adjusters. There really are some good adjusters out there that that we can work with, and they're professional, they're good, and they at least understand fairness. Let me say that. Okay. So, but at the same time, there's some adjusters, like people, not maybe as
good at players out there.
Yeah, maybe so. So anyway, but. Listen, to go back to the question, that's just standard kind of process. They do that. Interestingly enough, Kenny, a lot of insurance companies, they have pre-litigation adjusters and then adjusters that handle after you sue. So sometimes to change the adjuster, we will file suit because that usually means a reshuffling of the adjuster. Sometimes that we're just not G-hawing with an adjuster. Okay. We just, they have a position, we don't agree, we've talked about it, and no one's kind of budging. Sometimes just to kind of move the ball, we'll file suit because that means that adjuster will be reassigned.
Gotcha. Joseph, thank you so much for the email question. I think that probably a lot of people identify with that. You can always see in this email questions, rmlawcall.com, LawCall. Just Google it, find it, send us an email question. We'd love to get it.
Thank you for not saying the Google machine.
The Google, well, please, darn it, it was said. Yeah. All right, that takes us into our first break of the evening. When we come back, we've got more of your calls and questions here on LawCall.
Welcome back to WLOX Law Call, broadcasting from the Gulf Coast to the Pine Belt with lawyers from the Biloxi personal injury law firm of Reeves Mestayer, the attorneys for South Mississippi, including Jim Reeves. Known as a tough fighter, Jim has more than 100 cases with a recovery of $1 million or more and is recognized as a top 100 trial lawyer by the National Trial Lawyers Association. Plus Matthew Mestayer. Matthew served as an award-winning judge for nearly 20 years, has recovered millions for his clients, and is deeply involved in community issues on the entire coast. And hosted by broadcaster Ken Flanagan. The show has included over 200 guest attorneys from across Mississippi. This is WLOX Law Call.
And we're back here on LawCall on WLOX and WDAM. Our topic tonight is a good one. What your attorney can't say in court. Now, we go over every week what they can say and what they should say or might say. But this week is what they can't say. So we're kind of giving you a peek behind the curtains and on that side. So show Matt has been wanting to do for quite some time.
Long time.
Long time coming. All right, we're going to get to the phone line, speaking of long time coming, and go to our first call, which is Vicky. Vicky, good evening. What can we help you with?
Hey, Vicky.
I was hit by a Dodge Ram Dually. It was the man's work truck. I was rear-ended. His brakes supposedly failed. My medical bills with my children's exceeded the $100,000 insurance coverage he had. He took in return and put his business, all of his, everything he had as far as home, everything in his family member's name, so I couldn't recover any other damages as far as for my medical expenses or anything else. Is that legal? So what can be done about it?
Vicky, a lot of stuff going on there. Matthew, what do you think?
Yeah, well, that's a lot. That's about 10 questions in one, Vicky. But let me kind of hit it. That is pretty common. First of all, let me say this. What's really a little bit uncommon is how much insurance he had. As you know, in the state of Mississippi, the state requirement is $2,550. So usually in an accident, that means that the only insurance available is $25,000, which, as you know, Vicky, not very much. Usually an ER visit now wipes that out.
Pretty quick.
That's one issue. So what you're talking about is after the accident, that person hid assets, basically tried to make themselves what's called judgment proof. All right, so that is something that people can try to do, okay? But however, you can unwind that, Kenny, because it is not fair, all right? Those things are called fraudulent conveyances.
Okay.
All right, you cannot, if you're in trouble in a court case, if you've done something, you can't, to get out of paying money, give things to Kenny, give things to an uncle and say, listen, when the heat is off, when the court case is over, give me those things back. You can unwind those things, and it happens all the time, usually in Chancery Court. It's another lawsuit, Vicky. It's a different kind of than the wreck case, quite frankly. That's one type, but a second type is, it's a fraudulent conveyance. So you can actually, the court can go out and kind of grab those assets and kind of pull it back in under certain circumstances. What you look at, the first critical thing you look at is lack of consideration. If these were gifts, you don't generally give your uncle your house for no money. You don't generally give your cousin cars, houses. So when you start divesting, assets for no money or nothing coming back to you, that's usually a problem.
Gotcha.
It can be unwound.
So you're not allowed to lie.
Well,
you're not allowed.
Well,
you don't.
one way to say it.
Yeah, you just ain't allowed to lie about these
Well,
kind of
that's
stuff.
another thing you can't say in court. You can't lie in court either.
No, you can't. Well, that's
No.
true. Yes, you
Yeah,
can't
that's
say-
right.
That's
No.
true for
But
everybody.
no, that's a fraudulent conveyance, and that thing that happens. And but also let me say this once again to Vicki. This is a kind of a third part of your question. Generally speaking, when there is limits like that of insurance of say $100,000, as you said, in your medical bills or more.
Right.
However, it is usually your attorneys they will have to go to your medical providers and say, listen, Vicki is not recovering 100%.
Yeah.
She's the one that got hurt. You're going to have to come off your bill. You know, you're not going to get 100%, and she's not.
Right.
So, you know, that's kind of a second negotiation that happens. So, you know, I hate that. It sounds like you had quite an injury there, over at least 100,000. But I guess there is some hope that those conveyances can be pulled back, and you can, you know, get some hopefully fair recovery.
Matt, it sounds like Vicki needs an attorney on this. It just doesn't sound like you can come close to doing this by yourself.
No, certainly the fraudulent conveyance action, and I would, yeah, you'd want a lawyer on both ends. But I have to tell you, you know, as we talk about a lot, you know, talk to when you go to a lawyer, ask them they do this kind of work, and it's okay to, you know, sometimes with lawyers, it's okay to say, if we're not going to file a suit, if it's just going to be a settlement, will you take a lower fee? You know?
Okay.
Those are fair conversations to have.
You can negotiate a little bit.
You can have that conversation.
And
they may say no.
Right.
And you say,
No.
well, thank you. I'll take my file elsewhere.
Right.
But,
or you come to an agreement.
or you come to an accord.
An accord.
An accord, as we
All
say.
we need in this country is a few more accords.
Some nice accord would be nice.
Accords would be nice.
Yes, it would be.
All right, Vicki, thank you so much for the
Great
call
question.
tonight. Yeah, it really was. Detailed question. I would say definitely follow up with an attorney or definitely Matthew or Jim when you get a chance on that.
Plenty of good lawyers would love to help her out on that.
That's
But
right.
definitely, that's really two cases in one she's talking about.
All right, we got another hot email for you, Matt. These things are coming off the presses right now.
Okay.
This comes in from KJ. My brother was in a wreck and ended up needing surgery. But when he was in the middle of the insurance claim, he made a mistake. He made the mistake.
Told the truth?
Yeah, he told the truth. No lying. Like I was saying, Georgia, don't be
Told the
lying
truth?
now. He was in a wreck 20 years ago, so now the insurance company is saying his injury was pre-existing and not covered. What can he do? KJ just said a little too much there, Matt. Is he in trouble? Is this workable?
It's very workable.
Okay.
No, he's not in trouble, but you know, that's a very common refrain.
Okay.
Particularly, you know, with KJ, with any type of back injury, something like that, that I promise you, Kenny, that's always, you know, what's your prior history? Well, have you had back problems before? So anyway, Mississippi follows, Kenny, what's called the eggshell rule, which means the eggshell rule. Eggshell rule. So
we had a graphic on that.
Yeah, I know it. So you take your clients as you find them in Mississippi. So
Okay.
for example, if you're walking around, if you're Kenny, you're walking around, and let's just say your back is 90% bad.
Okay.
That you're getting by, but you're 90% bad, and you're in a wreck, and that wreck bumps at that 10%, and you need a surgery.
Okay.
You shouldn't be penalized because you have, you know, you kind of walked in with the bad back.
Right.
All right. So you take your plaintiffs as you find them. They can't come in and say, well, he had a bad back anyway. It's not our fault. Too bad. So sorry.
Right.
You know, basically what they look at is nonetheless your accident was the precipitating cause of his need for surgery. It doesn't matter that Kenny had 90% bad back, 80% of bad back. He wasn't having that surgery until your wreck bumped him that 10%. So it's on you.
Gotcha.
So.
And I just made us a graphic.
Eggshell rule?
Eggshell rule right there.
Yep.
Top-notch graphics.
We're on a
right
tight budget. I'm so glad to hear that.
I had to reuse the paper.
Oh, please.
On this thing.
Lord.
Matt, that's a great point on that side. And I think a lot of people haven't really thought about that. It would be terribly unfair to go the other way with that.
That's right. But let me say, you're still going to hear it, okay?
Right.
I promise you, Kenny, it's going to be a topic in any case that involves a back injury, a neck injury, anything like that. You know, they're going to inquire about it. They're going to kind of raise some sand about it, which is why but listen, let me tell you, it's always better in your case, and cost of life in general, right, is to be very truthful.
Yes.
To be a good historian to your doctors. If you've had, prior issues, say it. Just go ahead and put it on the table. You're not going to be penalized. The law has you covered, but there is trouble if you try to hide something and just try to kind of work the information around. Just be honest, and we'll go.
The eggshell rule is there to protect you. Right there, top graphic.
We're going to be looking for a new host.
We're going to be looking for new graphics right here. All right, that takes us into our final break of the evening. When we come back, more of your calls and questions for Matthew, plus contact information for him and Jim here on LawCall. Oh, I can't.
It
I
happens.
never get enough. I never get enough of this music.
It goes so fast.
It
Kenny.
does. It really does.
Really does.
Saturday night's just so much fun here on LawCall.
It is.
Here's that contact information I was promised you. Jim Reeves, Matthew Mestayer, Reeves and Mestayer, 228-374-5800. 5151. They have your toll-free number there as well. And rmlawcall.com, which we were referencing a little bit earlier. You can send us all your email questions with that. And the boys always got updates on the website. Matthew, phone line's hopping here. You want to try to get one more in?
Let's do it.
As we wrap up here.
Yep.
Going to go to line 1 and talk to Dwayne. Dwayne, good evening. What can we help you with?
Hey, Dwayne.
I was just curious as to why insurance companies take so long to reach a settlement long after, everything has been confirmed that they were, guilty. That that person that they represent was, was the cause of accident.
Dwayne, I think we're picking up on a theme here. Timing is everything, isn't it, Matthew?
Indeed. Yeah. Listen, I'm not trying to be dismissive with that question, but yeah, listen, I hear you, and I'm frustrated with it as well. It's just very common. Let's just say, kind of as I mentioned earlier, in the claims process, they're not required to be fair, reasonable. They have rules they have to follow, but they want to get your claim settled as quick as they can. And sometimes they just know if they drag it out long enough, people just kind of give up. Honestly, a lot of times that's why people end up in my office.
Right.
Because they've tried to resolve it. They can't get any headway. They've thrown their hands up. They're like, what do I do? And I'm like, well, I'll take it over. But I've said it 100 times. If claims folks were a lot more reasonable and quicker and more fair with the people that came to them, I'd be maybe doing a different type of law. But as of right now, it looks like
you're going to be employed for a while.
Job security is on my side.
Well, you still got a couple more kids to get through school.
Sure
so that's right. All right, Matt,
Four.
our topic tonight was
Thank you.
What we can't say. Dwayne, thank you for the question tonight. Really appreciate it.
Good luck.
Let's go back over real quick as the show's wrapping up. Let's go over the kind of the top 3 things that you're not allowed to tell a jury about when you make it into that courtroom.
Insurance, settlements, and if you fix something after someone got hurt, and you went out and tried to correct it and make it better. I had a fancy legal name for it, but that's really what it is. The law encourages people, if someone gets hurt, if you've done, if there's a condition on your property, something slippery or something bad stairs, they want you to fix it without being penalized.
Gotcha. And what was the fancy name for it?
No, you're going to throw it.
No, I'm just curious.
Promise not to show the
I'm not going to show the egg. Say it again.
It's called subsequent remedial measure.
It's
subsequent.
No, subsequent afterwards.
Remedial measure.
Sure.
Please don't show the egg. Sure.
I'm not. It was just. It's funny because when we wrote the graphic for the show, it was supposed to be done got fixed afterwards.
Done
got fixed. We done
fixed it. Kenny.
We done fixed it. And Matt, let's go over again. This show is important to you because there is so much time when y'all go into court, you and Jim and all attorneys, and there are things that you just can't present to the jury. But if the juror knows it, if somebody in the case knows it, that's fine. But you're just not allowed to say it for all sorts of rules.
Right, you do. Listen. All we want is fairness. Okay, all we want is fairness to our clients, and this is a big deal. And all Jim and I do is represent people trying to get a fair shake, trying to get reasonable compensation. And this rule affects people, right? It affects recovery, and it's just something we wanted to put out there and let people know. There are other things, but this is a big deal. If you're called in a jury in a civil case, I promise you the other side has got insurance. Now, that doesn't mean you should change what you do.
Right.
It doesn't mean you should penalize them, but I think it's fair information that everybody should have. I'm just a big proponent. Let's
just tell everybody.
Let's just everyone should know. Let's just write. So there you go.
And there is a financial side to that. The reason you say that, if it's making it, and I'm just talking about the dollars and cents side, if it's making it all the way to court and a jury and a civil trial, there's money to be made or lost on either side. So there probably means insurance.
Absolutely, and it's just, as I say, it's critical information, Kenny, and it's just one of those things. And we hear that a lot, because I have clients and they're like, well, when we're at court, we'll just talk about it. I said, no, can't. And they're like, what do you mean you can't say it? So, I get it, I understand the rule, but that's just one of the things we live by. And also know, Kenny, that those rules are emerging, right? The law is looking at those things, they're tweaking, they're tucking it. So that's the status of the law. Probably will be my entire career, but the law is a moving thing for sure.
Speaking of tweaking, we got to tweak the end of the show. That is all the time we have for it. It goes so quickly on a Saturday night. Thank you so much for watching and listening. We really do appreciate it. We'll be back with Jim Reeves next week, but until then, good night.